Good afternoon, everyone. Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who are here early, thank you for waiting patiently. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Navigating the Path from Unofficial Adoptions to Legal Adoptions. My name is Haikal Akimi Hamzah. I'm a pupil in Chambers with Mawing Kwai and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of the talk. We have 3 speakers for today. Allow me to introduce Ms. Agalia J. Manusami, who is a senior associate in our criminal, civil litigation, family, and matrimonial teams. She graduated with a Bachelor of Laws from Aberystwyth University in Wales and was admitted to the Malaysian bar in 2014. She is experienced in various matters such as citizenship, family and matrimonial, general litigation, debt recovery, customs and logistics, and anti-money laundering. Areas of practice include citizenship, family and matrimonial, criminal law, general civil litigation, and constitutional law. Next, our speaker would be Ms. Jasmine Wee. Ms. Jasmine Wee is an associate in our dispute resolution, corporate, individuals and families, and employment and industrial relation departments. She graduated with Bachelor of Laws in the University of London, and her areas of practice include the laws on employment, corporate litigation, strata, adoption, citizenship, and immigration. She also regularly provides advice to clients on various strata management tribunal claims. Last but not least, we have Ms. Alyssa Dalila. She is an associate in dispute resolution and individuals and families departments. She graduated with a law degree from International Islamic University Malaysia and was admitted to the Malaysian bar in 2023. Her areas of practice range from general litigation, such as debt recovery, commercial litigation, divorce proceedings, adoption, and citizenship matters. She is also involved in Sharia adversary matters. She regularly deals with adoption and citizenship cases. For our talk today, we have first Ms. Jasmine, who will be speaking on the problem with unofficial adoptions and investigations by government officials. Next, we have Ms. Alyssa, who will be speaking on options and requirements for legal adoptions. And also, we have Ms. Agalia, who will be speaking on Malaysian citizenship for adopted children. We will then conclude with the Q&A session. If you have any questions, please don't forget to type it up in the Q&A chat box. Now, I will pass the floor to Ms. Jasmine.
Thank you, Kimi. Good afternoon, everybody. So, as Kimi has mentioned, I will be your first speaker of today, and I will be taking the first two talk points, which include the problem with unofficial adoptions and investigations by government authorities. We'll start off with problem with unofficial adoptions. As you may or may not know, there are different types of adoptions, one of which is under the Adoption Act 1952. So under the Adoption Act, these adoptions are only applicable to adoptions by non-Muslims. Children adopted under this act are considered to be born to the adoptive parents in lawful wedlock. So what that would mean would be as if the adopted parents are the parents that gave birth to the child, essentially. So upon an adoption order being made under the Adoption Act, all rights, duties, obligations, and liabilities of the birth parents will be extinguished. Any right to inheritance under the Wills Act 1959 and the Distribution Act 1958 will be transferred from the birth parents to the adoptive parent. For a registration under the Adoptions Act 1952, it's only applicable by Muslims, but it is not restricted to Muslims only. If you go for an adoption under the Adoptions Act 1952, the fact that the child is adopted will be made known to the child, and they are silent on the rights of inheritance. So the child will inherit for the birth parents and not adoptive parents, and it is also silent on the legal effect of registration. I'll get into this a little bit further at the end as to why it has to be made known to the child that they are adopted. For unofficial adoptions, that would mean court involvement is not present in terminating parental rights of any living birth parent. So there's no legal relationship between an adoptive parent and the child, and adoptive parents who often raise their child as their own. While it is unofficial, it is very common practice, especially in Malaysia. We of course do not encourage it, but it's a common occurrence because of a lack of awareness due to its consequences. So individuals, they often go through unofficial adoptions because they want to avoid the stress of having to involve the court and lawyers, because adoption process is very simple, but I think a lot of people, maybe they are intimidated by the courts, so they choose to just raise the child as their own. Popular examples that we have seen for situations leading to unofficial adoptions would be baby dumping, especially teenage pregnancies where out of fear they perhaps just leave the baby in a fire station or in a baby dumping hatch. People raising children of their relatives, single parents who are unable to adopt, older individuals that face difficulty in adoption, the high costs of adoption, and step parents adopting without the consent of the biological parents. So there are of course many reasons people choose to unofficially adopt the child, but these are just one of the more common ones that we have come across ourselves. So the problem with unofficial adoptions is, of course, as mentioned earlier, inheritance laws, an inability to obtain accurate genealogy information, a difficulty in obtaining accurate family medical history, investigations by government officials, and as well as a threat to citizenship status of the adopted child. When it comes to inheritance, under English common law, only blood relations of a deceased were capable of inheriting property. What this would mean would be, even if your children are illegitimate, so long as they are your blood children, they will still stand a chance at inheriting from your estate. Whereas an adopted child technically is not blood related to a person. So if there are no legal documents which state that you have decided to form a legal bond between you and this individual's child, then technically this child cannot inherit anything from you, regardless of whether or not you have raised them as your own or not. So in modern times, adopted children can now inherit property equally as biological children are able to. The problem now arises when a deceased dies intestate and there's no direct evidence of a contract to make the adopted child an heir. If you have a will made, then you can specifically bequeath property to anybody that you want, including your unofficially adopted children. But say if the death was untimely and you did not have a chance to make a will, then there lies your problem. So under inheritance as well, under Islamic intestacy laws, there are limited circumstances that will permit a person to receive an inheritance. So this would include things like marriage with family relations, marriage, or something called wala. Islamic intestacy laws further require beneficiaries to be Muslim in order to inherit property from Muslim adoptive parents. Extra care is needed in managing the inheritance of a Muslim adoptee, ensuring that it will fall in line with the existing laws, Islamic laws. So when it comes to Islamic inheritance laws, from my limited knowledge, it would mean that certain portions of property only can be bequeathed to your family and your children. If, say, you are a Muslim family that has adopted a child that is seemingly non-Muslim, then that child will not be able to receive anything from your inheritance from your estate. Inaccurate genealogy information. So of course, this is a common one. There are lack of records leading to an inaccurate personal history. It's a commonplace issue before open adoptions became the norm. And inaccurate medical history, when a child is not officially adopted or a child is not told that they are adopted, and there is a difficulty in screening for hereditary diseases, there's a possibility of falsified medical records and a difficulty in uncovering any undisclosed medical conditions, and a threat to citizenship of the children, which we will explore a little bit further into the talk later on. So upon discovery of an unofficial adoption, child citizenship status may be left up in the air. So natural citizenship rights for the child will be denied, limiting their opportunities to live a full life. what we mean by this, or rather what I mean by this, is when a child is born and you report their birth to JPN as a baby, they will issue the baby perhaps a green certificate stating that they are a citizen. But later on, when they turn 12 and you go and apply for an IC, you would then realize that the child perhaps does not have any sort of similarities to the parents, and JPN may confiscate the child's birth cert and then reissue them with a new birth cert, a red color one, which will say that they are not a citizen. So 12 onwards, these unofficially adopted children will grow up with quite a tough life, with none of the benefits that are afforded to natural citizens of Malaysia. And now we have investigations by government officials. A scenario example in this instance would be adoptive parents who record their names as the child's parents on the birth certificate, meaning they picked up this baby from somewhere and they decide to go to a clinic or they go to JPN, and when they ask to record down the name of the birth father and the birth mother, they put their own name instead of the biological parents' name. So the child will now be provided with a green certificate, as I mentioned earlier, stating that they're a citizen. So now the adoptive parents, they want to apply for an IC when the child turns 12. And then NRD, otherwise known as JPN, they will observe any discrepancies. Usually, sometimes people think they can get away with it because the children look like them, but it's not just about the physical appearance of the child. It really depends on the officer that you come across when you're at JPN, and this could be a range of different reasons that they decide to get suspicious, or one of which is the behavior of the parent while they're at JPN. So an investigation will be launched by the NRD and the child's birth certificate will be confiscated. So an investigation under these circumstances usually will mean they will call you into JPN for questioning. They will ask you, when did you give birth, ask you details, everything about the child's birth, and then perhaps more than likely, we have seen recently it's been a trend for JPN to ask parents to do a DNA test to prove that you are the biological parent of this child. So the child will then be reissued with a red birth certificate saying that they're not a citizen of Malaysia. Growing up from then onwards, they'll be unable to obtain an IC, a passport, they'll be unable to open bank accounts, attend school, and a plethora of other reasons. So under the Births and Deaths Registration Act 1957, it is a penalty for false information, false entry, or a destruction of entry. This will be applicable to persons who willfully make or permit to be made for the purposes of registration any false statement. Persons willfully or knowingly furnishing or permitting to be furnished any false information touching any of the particulars required by the Act to be made known. So this is when, as I mentioned earlier, when you register the baby's birth at JPN and they require you to fill out the information forms on where this child was born, who these child's parents are, and this is what they will get you for. So this is also a penalty for false information, false entry, or a destruction of entry, and it applies to persons making or permitting to be made any false entry in any register knowing the information to be false. And under the National Registration Regulations 1990, any persons that are applying for an IC that make any statement or give any information which is false in material particular, these would include full names of the child appearing in the birth certificate, place of birth, the child's citizenship status, and it really does not matter if you, as the person applying, the parents of the child, believe this information to be true or false. It does not matter. So long as you have filled it out, they are just going to assume that you had full knowledge and you will be charged under the National Registration Regulations 1990. So this can be found in Regulation 25 of the National Regulations. And every offence that can be found under Regulation 25 sub 1 will be a seizable offence, meaning persons liable to registration or re-registration under these regulations who fail to register or re-register at or within the time prescribed by or in pursuance of these regulations. Persons giving any particulars, making any statements, or giving any information which is false in material particular, whether or not he believes it to be true or false. Persons who fail to comply with a summons or a requisition of a registration officer. What this means is if JPN asks the parents who have filled in the form to come in and comply with the interview, or as it says here, the summons, and you refuse to go, then they are well within their rights to charge you. Any persons without lawful authority making any mark or entry upon or erases, cancels, tempers, or alters any mark or entry contained in or otherwise defaces or destroys an IC or any part of the register kept in the central registry or transfer an IC will also be charged. Persons without lawful authority or reasonable cause that obtain more than one identity card or makes use of a forged identity card or an identity card other than his own, or possesses any false identity document issued under these regulations or any other identity document which is not in his name. So this came about because we have heard stories of people who believe they can, because the child, they were caught by JPN and their birth certs were confiscated and they were not able to apply for an IC. So they decided to purchase, for lack of a better term, a fake IC, and they decide that they can use this to go about their life. But if you are caught, you will be charged. So persons who also send or takes an IC out of Malaysia, unless they've been exempted, they've been allowed to do so under the Act will also be charged. Persons who are a parent or a guardian of a person under the age of 16 years that conduces by neglect or otherwise to the commission of an offence against these regulations by such persons who unlawfully issue ICs, persons who forge or reproduces an IC, public officers save in the public interest and the permission of the Director General or for the purposes of any criminal proceedings who publish or communicates to any person any information contained in the register or any book or record made under for the purpose of carrying out the provisions of these regulations. Persons who unlawfully deprive a person of an IC. Persons who, without lawful authority or reasonable excuse, they are in possession of an IC that does not belong to them, or persons that are disobeying or obstructing passively or actively any registration officers in carrying out their duties. What we went through just now was basically a list of seizable offences under Regulation 25 Sub 1 from A to P. If you'd like to look at it a little bit more, you can find them under Regulation 25 Sub 1. So liabilities of the parents, essentially, if you get caught in an unofficial adoption situation. So for birth certificates that are issued after the year 2017, the punishable offence will be that it results in an imprisonment term that is not exceeding 3 years and a fine not exceeding 20,000 ringgit, or they could decide to charge you with both. For birth certificates that are issued before 2017, the fine will be 3,000 max and it will be an imprisonment term of 2 years or both. Another thing we have seen commonly recently is parents who have been caught by JPN. They are, for lack of a better term, forging documents, applying for ICs for their unofficially adopted children, is that JPN, they will be asked to spend a night in JPN, either one parent or both parents we have also seen. And essentially you go through the processes, you go to court, you'll be arraigned in the morning and you'll be taken to JPN to spend 24 hours there. So all this before 2017 and after 2017, the difference came about because of the Birth and Death Registration Amendment Act that came to force in 2017. That will be all for me. I will hand it off to my colleague Alyssa.
Okay, hi, good afternoon, everyone. My name is Alyssa, and I will be talking about the options and requirements for legal adoption. So I'm sure some people might be a bit spooked about all the charges and liabilities that Jasmine has spoken about earlier. But rest assured, there are options and avenues for proper official adoptions that would enable you to go through about this process very smoothly, which is the aim of our talk today. Basically, what Jasmine has said previously, there are two official ways adoption applications in Malaysia. We have adoption by way of the Adoption Act 1952 and the Registration of Adoptions Act 1952. So we commonly refer to these as, one of these is a court adoption and the other one is a de facto adoption or a JPN adoption. So like Jasmine explained previously, the Adoption Act 1952 or court adoption is only applicable to non-Muslims, and the Registration of Adoptions Act can be for both Muslims and non-Muslims. So how to apply? So we have the formal application to the court for a court adoption and also an application to the JPN for the Registration of Adoptions Act 1952. But what I would want to expand more on my session are the conditions and the requirements needed for both of these applications. So for a court adoption, which I will refer to these as a court adoption and also a de facto adoption from now on. So for the court adoption, we know that the prerequisite conditions is that the child must be in the care and possession of the adoptive parents for 3 consecutive months before the court order. And then for Registration of Adoptions Act or the JPN adoption, the child must be in the custody of the adoptive parents for 2 years before the date of the application. And when it comes to the birth certificate, the original birth certificate, post-adoption, both of these certificates will be surrendered to the JPN. But in the case of court adoption, a new birth certificate will be reissued. Just like Jasmine said earlier, it will be as if the child was born from your marriage and will not be considered as an adoptive child. But for a JPN application, it will be surrendered and it will be replaced with a certificate of adoption, which I will explain further after this. Due to this, the identity of the adoptive parents post-adoption will also be different. So for a court adoption, you will be known as the parents, as if you are the biological parents of this child on the birth certificate. However, for a JPN adoption, you will be known as foster parents on the certificate of adoption. And when it comes to the right of inheritance, previously, like Jasmine said, if it was done properly with the will, the child can or will be able to inherit from the adoptive parents. Further requirements for a court adoption, and these are usually the documents that we will request from clients who are willing or who want to proceed with a court adoption. We will usually ask for the IC, the birth certificate of the child, if there was a first and second, if there was a JPN investigation. We will ask for your marriage certificate, Proof of employment, salary slips, and proof of assets is during the application, we would like to prove to the court you are able to sustain this child, you are able to fend for this child. So proof of savings is also important. Details of the child's schooling and education, immunization records, and also pictures of family with the child. This will all be inserted into the application for a court adoption. One of the usual complications that you may face in adoption proceedings is when the biological parents cannot be found or the biological parents refuse to attend court for this specific child. So what we would do usually is we would file a notice of application for the dispensation of the consent of the biological parents. So what the court usually needs is the consent from the biological parents that they are willing to give this child away. But if we do not know who these biological parents are, which is usually the case, we would put in this notice of application. And what the court would usually require us to do is to put out an advertisement in the newspaper, the details of the child's birth. We don't reveal any names, we don't reveal anything, we just reveal there was a child who was either found abandoned or who was born in a specific hospital on this specific date. Those are the only details. So for example, these are certain examples of advertisements that we have done. So you can see here that we don't reveal any names. We just say a male baby who was born and abandoned in Klinik Bersalin Sunway Petaling Jaya on this date. And we also do, if the baby was brought up, in a Chinese family, or the baby is assumed to be a Chinese baby, we would put it in a Chinese newspaper. We would have it translated. So what this would do is we will usually wait for about 2 weeks to see if anybody comes forward with any information. And I would say usually the case is that we don't receive any calls or anything or any information. So we inform the court. We don't know who the biological parents of the baby are, and usually the court would proceed with dispensing or excusing the consent of the biological parents in an adoption. This is what will usually happen in a court adoption proceeding. This is just a summary. So what we would do is we would file the documents, and then we would do the notice of application to dispense the consent of the biological parents after we file them. And we will usually get a first hearing date, which is where the attendance of both the parents and the child is compulsory. So at this first hearing date, the court will fix a final hearing date, and we will obtain the order to dispense with the biological parents' consent. And then the court will appoint a guardian ad litem, or usually this is a JKM officer, to do or to conduct a house visit. So between the first hearing date and the final hearing date, there will be a house visit. And between the first hearing date and the final hearing date, it would take about, I would say, 5 to 6 months between those two hearing dates for the welfare house visit. And after the JKM officer does the house visit, they will produce a report which will be submitted to the court. At the final hearing date, the court will consider the report and approve the adoption application. So this is what usually happens during a court adoption. But for a de facto adoption, which is the JPN adoption mentioned earlier, there are certain requirements that are, as mentioned, they're a bit different. So one of the obvious requirements or more different requirements are that, firstly, the child must be under the age of 18. And this is based on the Registration of Adoption Act 1952, where it says here that any child must be under the age of 18. And the second one is that the age requirement for these adoptive parents must be 25 and above. And the age difference between the adoptive parent and the adoptive child must be 18 years difference. Unless the adoptive parent has blood ties to the child's biological parents. For example, you're adopting your niece or you're adopting a relative, then the age requirement will be a bit lower, which is 21. And this is based on the Registration of Adoptions Act 1952. The third requirement, this is the one that's a bit trickier, I would say, is that the child must have been in the custody of the adoptive parents for at least 2 years. And this is, it's stated specifically in the Act that the child must be not less than 2 years continuously and immediately before the date of such application been in such custody and has been so brought up, maintained, and educated. So this means that the child that will be adopted under the Registrations of Adoption Act must be below 18 and must be in the custody of the adoptive parents for at least 2 years. So how do you prove that this child has been under your care for 2 years? What we usually do is we require documentary proof, such as a consent letter or a statutory declaration by the birth parents. But this must be done during the handover of the child to the adoptive parents. So a 2-year period starts from the date of the handover and not the date that the statutory declaration was affirmed. Once the baby is handed over to you as adoptive parents, you must sign a consent letter, you must sign or affirm a statutory declaration to prove that the baby was handed over to you 2 years ago when you're doing an application for a de facto adoption. What happens upon a successful registration? You would have to pay 30 ringgit to the JPN, and then your child's original birth certificate will be surrendered to JPN, and then JPN will issue a certificate of adoption. So it has the same validity as a birth certificate. You can use it for school registration, you can use it to apply for an IC, for a passport and other official transactions, but at this point, it is a certificate of adoption. This child will not have a birth certificate per se. In cases where you would not want to, inform your child that they were adopted, but they have a certificate of adoption, it's inevitable. So this is what a certificate of adoption would look like. So you can see here, there's the name of the child, the gender, the place where the child was born, everything, but it would say there in big bold letters, Daftar Anak Angkat, certificate of adoption. Those are just the options and requirements. Those are just the options for the types of adoptions that we can do here in Malaysia, and also the requirements, and also a bit of a summary of how these two processes would go. And that is all from me. I will pass the floor to Agalia for the citizenship part of the adopted children.
Good afternoon and welcome for attending our talk for today. You would have heard our speakers previously, Ms. Jasmine and Ms. Alyssa, explaining about how to go about informal adoptions and how to legalize those adoptions for your adopted child. Well, the issue that commonly props up during these times is that once the JPN starts their investigation process, it is highly likely that your child's citizenship status might be affected. So what do I say by affected is that if they find that this child does not look like a Malaysian or does look like someone from a foreign state, it's possible that the JPN officers might actually give you a birth cert that registers your child as a non-citizen. So what we in Mawengkwai would usually advise our clients is to apply to legally adopt this child and subsequently apply for citizenship through an order of court. So statelessness, this might highly likely mean that your child might be stateless because they will not be recognized as a Malaysian and they will also not be recognized as a citizen of any other country. So statelessness is a very prevalent issue in Malaysia. It's an issue where individuals are denied basic rights and liberties such as education, the ability to open a bank account, the ability to obtain a passport, and so on and so forth. They might not even hold proper employment in the future. And even if they are employed, their employers can take advantage of these kind of stateless people by not paying them EPF and paying them their salary worth. At present, most stateless individuals in Malaysia are children, unfortunately. The common reason for this statelessness is unregistered births from irregular marriages. So what we mean by irregular marriages are children born out of wedlock are considered children of a product of irregular marriages, and they are regularly discriminated against. And there's a court precedent that says that if your father is a Malaysian and he has a child with a woman who is of a different ethnicity, of a different citizenship, then the citizenship of that child must follow the mother, which means if you're not married, then it must follow the mother, who might be a Filipino, Indonesian, a Vietnamese, or anything of that sort. Another common reason for these statelessness are also inconsistencies in the JPN's procedure at district and state level. So we have cases where a lot of our clients come to us and tell us that they go to a state level JPN and whatever they hear from them is not the same as what they hear from JPN Putrajaya. So these are the kind of confusion and inconsistent advice, so to speak, that they receive from JPN officers themselves. Okay, and there are also inconsistencies in relevant laws, and some other reason for statelessness are children born overseas to Malaysian mothers with foreign fathers. We will discuss this a little bit more in my next slides, so I'll keep that for that. And also refugee children are not recognized as Malaysian even if they are born in Malaysia and they are unable to go to their country to register their birth. So these are common reasons for statelessness. And as I've mentioned earlier, stateless people do struggle a lot and they face a lot of disabilities, so to speak. So one of those are an inability to qualify for benefits afforded to Malaysian children in public school system. So as you may know, the right to education is under the Federal Constitution, which is provided for until the age of 12, which means beyond beyond the age of 12, if your child does not obtain an IC, it is possible that they may be stopped from going to school, which is terrible. The next struggle that a stateless individual might face, the inability to open bank account. They might be denied education, especially tertiary education. There aren't many universities in Malaysia or tertiary education providers that will allow a stateless child to continue their studies. Okay, and then there's also inability to qualify for medical care subsidies in government hospitals. So if you were a stateless child, and although you were born here in Malaysia, due to your statelessness, you will not be provided the same subsidized treatment that a Malaysian might obtain at government hospitals. In that case, it's better to go to a private care in the end of the day. Okay? And then there's also inability to leave the country in the sense that they will not be able to obtain a passport. If you do not have a Malaysian birth cert that recognizes you as Malaysian, there's definitely no way that the immigration officers who would allow your child to obtain a passport under their own name. So this means a stateless person might just be indefinitely stranded in Malaysia without the ability to leave, without the ability to do anything. When we speak about citizenship, okay, the citizenship is provided for by the Federal Constitution, and we have citizenship by operation of law, which is provided for under Article 14 of the Federal Constitution, Article 14 1A and 1B. And there's also citizenship by way of registration under Articles 15 to 18 of the Federal Constitution. And finally, we have citizenship by way of naturalization under Article 19 of the Constitution. Okay, so under the current Article 14 1A is applicable for those who are born before Malaysian Day, which is 16 September 1963. But we rarely come across these kind of cases where people have been stranded stateless since their time of birth in 1963. So what I would like to do for the purpose of this talk is focus on Section 14, Article 14 1B, read together with Section 1A. So 1B applies to those who are born after Malaysian Day, which is again 16 September 1963, and read together with Section 1A of Part 2 of the second schedule and Section 19B of Part 3 of the second schedule, a newborn child who is found abandoned. So this is the operating word, found abandoned, is presumed to have been born to a mother resident thereof and is automatically a citizen by operation of law. So what happens when you apply, when someone invokes Section 19B before the court is that a Section 19B abandoned child is presumed to be born of a mother who is a PR of that place, which is Malaysia. And by that extension, it would be established that this child is born to a parent who is a Malaysian at that time. And that is the operation of Section 1A of Part 2 of the second schedule. So this case relates to, this was the finding of the federal court in the case of CCH, where the court found that a child who has been abandoned by the parents at the place of their birth is presumed to have been born to a Malaysian at that time. So for Section 1A to apply, it must be proven that this individual is born within the federation, i.e. anywhere in Malaysia, and at least one parent at the time of birth was a Malaysian citizen and is a Malaysian citizen or a permanent resident of Malaysia. The issues with Section 1A, when we speak about adoptive parents, okay, the issue of Section 1A is that the word parents that comes in Section 1A, that is mentioned in Section 1A, second schedule of the Federal Constitution, is not clearly defined. So the child's birth cert, which is issued, pursuant to an adoption order, is sometimes taken as conclusive evidence of the identity of the child's parents. The adoption order, which was spoken about by my colleague Alisa, does not automatically confer citizenship by operation of law. The reason for this is because what Malaysian authorities do within the JPN is that they tend to rely on the first birth cert that was issued to the child, which means a birth cert that's issued, say if you were to do a legal adoption, a formal adoption by court order, you would have to enclose at that time, during the adoption proceeding, you will have to enclose the original birth cert of that child. So it might state that the child was born to a Filipino mother or to an Indonesian mother or someone who is not a Malaysian. So what happens then is that upon adoption, you can request the court to direct JPN to issue a birth cert that states you and, if you are the parents, a husband and wife, to state you as the parents, that post-adoption birth cert should be accepted as conclusive evidence of citizenship. But that is not what happens at this time. So Section 9, read with Section 25 of the Adoption, 25A of the Adoption Act, presumes that the birth certificate, the post-adoption birth certificate, should be the only birth certificate that should be considered whether or not your child should be granted a citizenship. There are no express references of Section 9 of the Adoption Act to the child citizenship, but it can be taken to interpret Section 9 of the Adoption Act to include the rights of citizenship. So this, what I'm showing you on the screen right now, is sample of a post-adoption birth cert. So you can see that the birth cert is in red color, which definitely means it's bukan warga negara. So there is a difference. Sometimes it can be mentioned as bukan warga negara, which means that the child is a non-citizen. And sometimes the column could show belum ditentukan. So that means it's not yet determined. So these are the things that you have got to look out for. But these two definitely means that your child has not been recognized as a Malaysian post-adoption. So what is our advice to our clients who come to us with these kind of issues, is that we will definitely ask you to regularize this birth cert by going through a court order. So once an adoption order is obtained, the old birth cert is actually surrendered back to the NRD or the JPN for cancellation. This is why we state that once the child has been adopted and a new birth cert has been obtained, then that post-adoption birth cert should be the conclusive proof of the child's citizenship. A new birth cert is the official birth cert of the child, and the contents are to be conclusive proofs of acts relating to the child's birth. As mentioned earlier by my colleagues, what happens in a formal adoption, it is considered that the child was born in normal legal wedlock to the parents who are adopting the child. Any reference to the old birth certificate should be unlawful and should not be considered by the JPN. This is because original birth cert has already been surrendered to the NRD for cancellation, and it should be cancelled. I mean, it should not be considered for the grant of citizenship beyond after the cancellation. So the usage of the word adopted or any similar word will not appear in the new birth certificate. This is the difference that my speaker Alisa was trying to explain earlier. So the difference between a formal adoption is that you will get a birth cert that is reissued with you as parents to the child, and it will not show anywhere in that birth certificate that this child was adopted. So the Bill of Adoption Amendment Act 2000, the purpose of why that happened was to prevent the possibility that knowledge of the fact of being an adopted child would have adverse psychological effect on the adopted child. So this is why we encourage parents to formally adopt a child rather than going through a de facto adoption, for the simple reason that it could be your intention all along to not let the child know that they were adopted. However, it will not be possible if you were to go through a de facto adoption. And there are possibilities that this child, once having known that they are adopted, might actually try to look for any kind of information of their birth mother or birth father, would struggle to assimilate the fact that they have been abandoned or unwanted for that reason. The next section that would be applicable for adopted children seeking citizenship would be Section 1E of the second schedule of the Federal Constitution. So earlier what I was explaining is Section 1A, which is for JPN to recognize that an adoptive parent who are Malaysians ought to confer their citizenship status to their child. So this is the alternative provision to that 1A, where 1E says every person born within the Federation who is not born a citizen of any country otherwise, then by virtue of Section 1E, is to be treated as having at birth any citizenship which he acquires within 1 year afterwards. So what we are trying to say here is, pursuant to Section 1E, if a person has not acquired citizenship from 1 year of their birth, then they should be granted the citizenship of Malaysia. So this is commonly read together with Section 2 sub 3 of the second schedule, which commonly means that you are eligible to a Malaysian citizenship if you have not or if you cannot prove that you have obtained citizenship of any other country from 1 year of the child's birth. There is citizenship. We have already discussed citizenship by operation of law, and now I will move on to citizenship by way of special circumstance. So Article 15A of the Federal Constitution speaks about special circumstances where the federal government may cause any person under the age of 21 years of age to be registered as a citizen in such special circumstances as it thinks fit. So Article 15 application is usually done to the JPN, who will then go through the documents and sort out the requirements to then forward that application to the Home Minister. So our advice to our clients usually is that this Article 15A does not prevent you from seeking a court order for the same recognition by way of operation of law, which means you can go for Article 15A concurrently with an application for citizenship under Article 14. For Article 15A, it usually takes a long time for these applications to be heard, and there is no guarantee that your child might actually be registered or recognized as a Malaysian at the end of the process. We have had numerous clients who have come to us who have waited 2-3 years until their application has been rejected, and then they come to us and say we have tried applying for 15A, but it was just rejected after 3 years. And usually this is the case where we rush for time, because as you can see on the screen, there's only a certain time limit where someone can apply for Article 15A, which is until they turn 21. And once they miss the boat, then there's no way that they can apply for citizenship pursuant to Article 15A. Then the only thing that's left for them would be to apply for citizenship by operation of law, which means you will have to go to court to get yourself recognized, because the federal constitution states that 21 is the age of adulthood. So anyone under the age of 21 is still considered a child. Under Article 15A, you can make an application if you're an illegitimate child, if you're a stateless child, if you're an abandoned child. All these are the categories of a child who can apply for citizenship pursuant to Article 15A. But there's one catch here, is that the application must be made by the Malaysian parent. Otherwise, the JPN is not going to accept the application for or on behalf of the child. As I've mentioned, these were special circumstances cases where the JPN and the NRD and the Home Minister will consider. But however, special circumstances are not particularly defined within the Constitution. It generally applies to children born out of wedlock to foreign mothers. As I've mentioned earlier, if it's an illegitimate child born to a Malaysian father and a mother of any other citizen, any other country, then the child must take the citizenship of the biological mother, and it will not follow the father. So this is an interesting fact that Malaysia is one of the only 2 countries in the whole world that does not recognize citizenship through its father for illegitimate relationships. So that is something that you will need to keep in mind. Okay, and arguably this provision also applies to newborn infants who have been abandoned. So as I mentioned earlier, Section 19B does recognize abandoned babies as citizen by operation of law. However, this does not happen automatically. There are many instances where people are still required to go and knock at the court's door and say that, hey, my child was abandoned. Please recognize my child as a Malaysian. There's nothing else we can do. And these kind of applications do not get automatic recognition by the JPN. Unfortunately, we are still fighting these kind of little Napoleons going around in the JPN. Okay, and the applications under Section 15A can be made directly to NRD. And as I mentioned before, it must be made by a parent who is a Malaysian. Otherwise, your application will be rejected. Part 3 of the second schedule, Section 17 of the Federal Constitution, provides that illegitimate children who are later legitimized can obtain citizenship. But as I mentioned, it will not be automatic. For illegitimate children, what we do usually suggest is for parents to regularize the birth, which means you will have to go through a legitimacy process, and a legitimacy process should also go through a court order. So you will make an application to court to legitimize the child from the time of the marriage, not from the time of the birth. So the catch here is that JPN only accepts the child's citizenship at the time of birth. What we have done is we try to legitimize the birth from the time of the marriage and convince the court that this child should be considered as a Malaysian and not as a non-Malaysian or a non-citizen. For the purpose of citizenship, any references to an illegitimate person's father or parent will be construed as reference to his mother. So this is quite interesting to note that it appears in the federal constitution, because whilst illegitimate children born to Malaysian fathers are penalized by not providing citizenship, the same is not applied to the mother. So what this means is that if a Malaysian mother who gives birth overseas to an illegitimate child, that child is automatically considered a Malaysian, thanks to Section 17, Part 3 of the second schedule. The argument of JPN to the recent argument that it says that if you were to legitimize all children born to foreign mothers and unmarried Malaysian fathers, then it would defeat the purpose of having us go through a marriage. But then that does not apply to a Malaysian mother who gives birth illegitimately to a child with a father of a different citizenship. The argument is definitely confusing, and we hope that the federal court will soon put an end to these kind of arguments. So as we mentioned earlier on the issue of abandoned babies, Section 19B of Part 3 of the second schedule provides that any newborn child found exposed in any place shall be presumed to have born thereof a mother permanent resident, unless it can be shown otherwise. It really falls on the duty of the JPN to rebut this argument that the mother is not a permanent resident thereof. In unlikely cases where they do go back and find for evidences of this person or the mother most likely what happens here is that we have seen birth certificates where there is tiada maklumat diperolehi in all columns, including the mothers, the fathers, and the only thing that is shown is the time and the place of birth of the child. So these are the kind of a newborn child who would qualify under Section 19B, where if you have taken their birth cert and you would see like there's nothing stated in the column of the father of the mother and nothing else stated there other than the place of birth. So these kind of babies, it has been established by the federal court that these babies who are found exposed and abandoned where they were found are born to a mother who is a PR or a Malaysian thereof and is automatically recognized under Section 1A, as I mentioned earlier. What are the legal avenues that we can look at for children who do not have citizenship post-adoption? Is that there are legal avenues that we would recommend, and what we recommend are two different processes. So one is you can apply for Section 15A, which we spoke about earlier, and the other one is that there's always a route to take, which is to go through the courts. So should an application for citizenship at the NRD fail, an application for judicial review can be made. An application for judicial review should be filed within 3 months from the date when the grounds of application first arose or when the decision was first communicated to the applicant. So this happens when you receive the rejection letter from JPN and then and you don't know what to do. So it should be filed within 3 months. The decision of the JPN or the Home Minister in rejecting your application is subject to judicial review. So what happens in a judicial review is that we apply for an ex parte application for leave to commence judicial review, and it shall be supported with a statement setting out the particulars of the applicants, the reliefs sought and the grounds on which the reliefs are sought, and an affidavit in support to verify the facts relied on. And a prima facie case in a judicial review, a prima facie case must be shown that the application for judicial review is not frivolous or vexatious and that there are substantial grounds supporting the application for judicial review. The hearing of the judicial review proper will take place once the leave has been granted. Usually, in my experience, if the application is made within time, that means within 3 months of the date of the rejection, the leave does not get opposed by the AG chambers. So this is one good thing that we have. Usually, in my experience, they do not object to it as long as it's within time. So time is of essence. Do not wait and do not delay when you do get the rejection letter. And the other thing that we commonly practice in Mawengkwai is that should an application for citizenship to NRD fail, we can file an originating summons. An originating summons, on the other hand, can be applied at any time. There's no time limit. However, we do recommend you to act in a speedy manner to show the court that you have been trying your level best to obtain the citizenship for your child. Whenever we file an originating summons, it shall be supported with an affidavit verifying the facts relied on, setting out the reliefs sought and the ground on which the reliefs are sought. So we have come to the end of the talk. I will pass the floor to our moderator, Kimi.
Thank you, Ms. Agalia, Ms. Jasmine, and Ms. Alyssa for your insights in navigating the path from unofficial adoptions to legal adoptions. We will now take questions from the participants from the Q&A chat box. The first question is, in what situation would someone choose to adopt a child under JPN and not via a court order? Perhaps Ms. Alyssa can assist us with this question?
Hi, yes, okay. So thank you for the question. So JPN adoptions are usually the only avenue for Muslims to formally adopt a child. So that is one of the situations where someone would prefer to choose to adopt a child under a JPN application. But most times people would choose to adopt via a court order because they would want to have their names on the child's birth certificate and have no indication that this child has been adopted. And because a child adopted via JPN application, as mentioned previously, would have to present his certificate of adoption in places where you would need a birth certificate. So most of the reasons why people choose a JPN adoption is usually because they are Muslims, but it's not limited to that. But I would have to state that usually a court adoption takes a bit of a shorter time. It usually takes about 6 to 9 months, whereas a JPN adoption application will usually take 2 years. So I have to keep that in mind as well.
Thank you, Ms. Alyssa. Now moving on to the next question. The question reads, can the adopted child inherit property if he or she is a non-Malaysian? Does any of the speaker would like to elaborate on this?
I'll take this one, Kimi. All right. So to answer your question, it really depends on the circumstances. If the property is movable, it shouldn't be an issue, but it is more complicated when it comes to land. So long as the foreign beneficiary falls under the requirements of Section 6 of the Distribution Act 1958, then there should not be a problem. And also, if the deceased has a will, you can bequeath any property you want to anybody that you want. But any transfer of land to a foreigner will require approval of the specific state authority. Certain parcels of land will also carry a Bumiputra classification, in which case a foreigner will not be allowed to inherit it.
Thank you, Ms. Jasmine. Now, moving on to our last question. Is court adoption a guarantee to successful application for citizenship, including adoption of own blood children but are stateless?
Kimi, I'll take this. Okay, to answer this question, I wouldn't say it's a guaranteed success. So adoption is basically a procedural issue. As long as you have conformed to all the requirements by the Jabatan Kebajikan, an adoption is usually always a success. There's rarely a case where the Jabatan Kebajikan is going to object to an adoption, mainly because the welfare of the child is the most important thing. And if the officers have seen that the child is happy with where they live, there's usually no objections for the Jabatan Kebajikan to approve those adoptions. But in order for citizenship to be a success, if you're looking at your own blood child, what we usually would recommend is when we make the application for the OS, we would, before applying for the originating summons, encourage the parties to give their blood samples for DNA testing. What we try to do here is that to allow the court to have all information before the court, which means this child is your own blood child and therefore should be granted citizenship pursuant to Section 1A. We do encourage you to apply under Article 15A, which is a special circumstances. While waiting for the decision, there is no bar for you to commence the legal suit.
Thank you, speakers, for the insightful session. Before we conclude, I have a few announcements to make. Firstly, please join us again for our upcoming talk, which will take place on the 28th of February 2024 at 3 p.m. entitled Legal Insights, Navigating LAD Calculations in SPAs. The talk will be on the 20th February 2024 on Wednesday. Secondly, please fill in our feedback form and tell us what are your thoughts on our talk. The link to the form will be posted in the chat. Thirdly, do follow and like our social media accounts. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box. To our guests, thank you for joining us. We hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.